subpoenas, there are credit card information, criminal records checks, narrative reports by the investigators, witness interviews, tapes and transcripts of that. And if you look at particularly the Wright versus OSHA case, there were in the Wright versus OSHA, the government segregated its documents into 5 categories.
Well, how does that help me? How does that help me make a determination that the disclosure will reasonably interfere by just telling me that I've got 20 categories of documents? How does that help in any way?
Because you can see from the types of documents which are identified in these categories that these are the types of documents that if this develops into being a homicide or criminal case, might well be evidence or might well be supporting or corroborating evidence that the government would need to keep confidential in order to prosecute its criminal case.
So your argument is that you can infer from the nature of the evidence itself that it's relevant evidence in the criminal investigation?
Yes.
Does it matter if you have an investigation, not this case, have an investigation where you think there's a disappearance, you the parent, and the local police department is not that focused on it, but they've done some investigation, but if there's a disappearance, you don't think there's foul play, you just think that something happened for other reasons. And they're not really taking a hard look at it, but it's an open file, and if they get to it, they get to it. But you think time is critical here, and they may have learned something that you wouldn't know, but you'd like to follow up on it. Doesn't matter. If it could interfere with an investigation, however slow-moving, however back-burner, and however mental health-oriented in my hypothetical, doesn't matter. Right?
Your Honor, the police and the government have the discretion in a case like that where they don't believe there's any evidence or any possibility of there being a criminal investigation to release the information to Mr. Martin.
Let me ask you this. What do you do? I just don't know how you penetrate it. A police officer comes in and says, you're right, it's been 18 months. We think it's a missing person, but it could not be a missing person. We haven't given up on it. And every single piece of paper in our files, if we disclose it, might interfere with an investigation. The court says, what? Thank you for sharing that. I guess there's nothing I can find out. Well, what does the court do? What does the judge do that the officer hasn't already done? It sounds like nothing. Why is it in court in the first place?
I'm sorry, I'm just not understanding your question.
What is the role of the judge in a case like this? Police officer says it's ongoing, we don't know whether it's criminal, we don't know whether it's a missing person, I haven't looked at the documents, says the judge. What do you think, officer? Oh no, they're all privileged, judge. Here are the broad categories. You can understand broadly why that would be a problem. The judge says, well, thank you for sharing that, end of case. Doesn't the judge say, well, maybe we should look at some of that? Because there may be differing views on that.
In this case, if that were the case, then the judge could demand an in-camera review. The judge has the option of doing that. I do not want to suggest that Judge Vaughn could not have said, I want to see the documents. He could have said that. In fact, Attorney Mullen offered that to him, and he felt it wasn't necessary, that the showing that had been made to him, if you read the transcript, you'll see that offer was made to Judge Vaughn.
What exactly does monitoring, a detective monitoring the case each day mean? As I understood it from the record, that's what the state says the investigation amounts to these days, and I don't know what that means. I talked to Attorney Strelzin yesterday about whether or not the investigation was still active. He did indicate to me in some specificity that there are currently activities going on, and that this is very much an active case. But at the time the matter was put to Judge Vaughn, I could be wrong, memory might fail, the offer of proof was that every day a detective monitored the case or developments. And
Does that mean asking somebody if anything's happened? Does that mean doing what does that mean? You don't know? It's okay to say you don't know.
It's more than just looking at a list of cases and say, okay, has anything happened on the Murray case? No, and going on to the next one on the file. It's more than that.
Okay, thank you.
So I believe that this court should affirm Judge Vaughn's order finding that these fall within the law enforcement exception that they would potentially interfere with a enforcement action to protect the government's ability to bring to justice or to be sure that justice can be achieved for Maura Murray in the event that this turns out to be a criminal matter.
Thank you. Case submitted. Case submitted. Court will be in recess.